We're back inside the courtroom for a case that proves real life can be just as gripping as any TV drama. This time, the spotlight is on a housing dispute where the rules on paper collide head-on with the frustrations of everyday living. It's more than a checklist of cracked staircases and dripping taps. It's the story of how long someone can quietly tolerate unsafe, uncomfortable conditions before finally deciding enough is enough.
Hamilton Crossing versus Cheryl Chambers.
Good morning, Your Honor. Carissa Gandari, appearing for the plaintiff.
Good morning. Happy New Year to you.
And to you, Chambers.
Thank you.
All right. Where are we on this case?
Your Honor, I have my client present together with the maintenance supervisor, together with Jerry Dunham, the City of Ypsilanti Building Department Manager. I know he is, I think we're allotted 1 hour from 9:30, so short on time. So I don't know if you need testimony from Mr. Dunham in this case. I have a certificate of compliance that was issued in August. I have an email from Mr. Dunham indicating what happened when he went back to the property to re-inspect at Ms. Chambers' request in November. The property has passed, the stairs are in compliance, there is nothing pending at this time, and I have that documentation to show the court and Ms. Chambers, but I don't know, there's no tribal issue to the extent that Ms. Chambers does not agree with the City of Ypsilanti's determination. That's not really.
Today, we watch a tenant take a stand, facing a system that often listens more to documents than to the people living the struggle. And here we hit the heart of the conflict. On one side, the city insists the property has cleared inspection without a problem. On the other, the tenant paints a completely different picture. It's the kind of courtroom standoff we've seen before, where an official certificate claims everything meets the rules. Yet daily life inside those walls tells another story entirely. Now the question becomes,
Landlord, what the property, the status of the property is today, it is in compliance, and there's nothing that requires plaintiff to repair things that are up to code.
Chambers.
I have emails. I've been in touch with legal aid with Miss Kim, where conversations was between Miss Kim's and Jamaica Berry. Things aren't adding up. Now, Miss Waukesha Dorsey sent me an email on 8/23/2024, telling me that she would be at my house on Tuesday. Would you like to see this? Okay, this should be at my house on Tuesday, was the 27th. Okay, why would Jamaica Berry come to my home on the 28th if when Waukesha said that she scheduled an appointment between 8 and 11
comes, which carries more weight. Here, the inspector's neatly checked boxes and official paperwork, or the tenant's first-hand account of living through the issues day after day. Now the plot thickens, and the timeline starts to look like a puzzle missing half its pieces. We've got inspection dates that don't quite match up, overlapping visits that blur together, and unannounced mystery guests reportedly appearing. At the property, was there really a second visit? Or are we watching a scheduling mix-up spiral into
for the contracting city to come and open up the bottom of your stairs for the permit?
Okay.
Okay.
So, I'm sorry, I don't want to interrupt though. Go ahead if there's something.
So anyway, I've had contractors come from 2024. I had 3 different contractors come. The 3 different contractors came, told me the same thing. My neighbor's unit, her stairs was crooked, my stairs were slanted. It's even in the report from the city inspector herself. And then she writes,
Okay, but it's one of the things that you're going to have to understand. You could have stairs that are crooked. There could be, I'll say, defects in a premises. Mm-hmm. The question really for the court is, do those defects go to the extent of making the unit uninhabitable or not usable?
It's not unusual, but it's a safety issue for me because I have severe rheumatoid arthritis.
Well,
And I always
okay,
have
and
documentation from my
here's
doctor.
going to be the problem.
Okay.
Into full confusion. It's starting to feel like a real-life detective game, the housing edition where the big question is, who actually showed up? When did it happen? And what exactly were they looking for? Here's where the legal fine print steps into the spotlight. In the eyes of the law, something can look rough, worn out, or unpleasant, but that doesn't automatically make it unsafe. The judge isn't here to debate style points or comfort levels.
If it is a safety issue,
Mhm.
right, then the city would pick that up. They're not going to pass it if it's a safety issue.
Okay.
And from my understanding, they passed the unit, a CO's issue. And I'm not sure what I would try if I were to have a trial on the case.
Okay. I just don't think it's fair because I had 3 different contractors tell me the same thing. You had the contractor set to come in my unit after my stairs was done.
No, I hear you, but here's the thing. And sometimes what I have to explain to tenants.
Okay.
You rent a unit, and the unit, the landlord isn't required to make the unit perfect.
Mhm.
Okay.
I understand.
Right?
Yep.
And so, like I said, there can be defects in the unit.
Mhm.
Where it becomes a problem for the court is where, or for like these types of proceedings, is where the, whatever may be the issue, where there is a health or safety issue. The court's going to, in great part, either going to have to rely upon experts that you bring in to say that it's a safety issue. I mean, certain things I'll know are safety issues. Or what would be the inspector of the premises, which in this case would be the city,
Mhm.
to say, yes, this is a safety issue.
I understand what you're saying.
Okay. We don't have that here.
But the stairs is not the only issue.
Focus is razor sharp on one core issue: habitability. If the city has already stamped its approval and declared the property safe, then challenging that verdict isn't easy. Without a certified expert ready to back up your claims with solid evidence, you're facing a steep climb against a system that leans heavily on official reports. You can sense the frustration rising with every exchange. The tenant, already dealing with arthritis, has brought in not 1, but 3.
I had a work order put in on 10/23 that still has not been completed.
Okay.
So why should I keep
What
paying
work
rent for
or-
things
what-
that's not going to be
What
complete?
work order?
I have a work order on October 23rd that I placed with Brandon for my toilet that has been repaired 4 times. The handle still will not go up, and it still ain't been repaired. That work order went in on October 23rd.
Okay, that sounds to me like that's just a float in the tank. I mean,
But they didn't change it 4 times, and I still have the same issue.
okay.
And it's like I said, it's not like I don't want to pay my rent. I like where I live
Oh,
at.
I know.
I love where I live at. I've
Pardon?
been there for 12 years.
Right. No, I'm not. That's not what I'm saying.
Okay.
I'm not saying that because you told me that, and I believe you. It's the issue really is going to be what it amounts to.
Mhm.
Now, if they've been out and repaired it and the same problem happens, then something is occurring, but not something I don't think that would amount to a health or safety issue. It more is going to amount to the repair, what parts are using, what type of tank it is. I mean, it doesn't sound to me like that's a health and safety issue. Bottom line is, and again, it comes down to this, that the unit passes.
But there's too many conflicts.
3 separate contractors to confirm her concerns. Yet, despite their support, the case still isn't gaining momentum in court. In landlord-tenant law, the battle often comes down to strict thresholds. unless the problem crosses the clear legal line into making the home unsafe or truly uninhabitable. It's likely to land in that tricky legal gray area, the space where repairs might be needed, but not enough to trigger a court order.
Like Jamaica Berry said she came to my unit on August 28th and said everything was fine. She found nothing wrong with my stairs. But that's not correct, because if the contractor and the city inspector came to my house on the 27th, why would she come back the next day? I have an 80-pound pit bull.
Ma'am, I don't know.
But what I'm saying to you is, she said she came back to my unit. She's the one that said my stairs were slanted in the first place.
Okay, I hear you. But what I'm saying is, whether they're slanted or not, whether somebody comes back, whether somebody does any of those things, I don't know that that's going to matter to me. Okay, because when the unit passes, the unit passes.
Okay, but
they don't pass.
Okay.
Then yeah, they don't pass. And the same thing happens then on the landlord side. If the unit doesn't pass, the landlord can't sit up there and say, no, that's good. This is a circumstance where the unit passes. It's gone through its inspection. The certificates have been issued. There isn't anything, other than to sit here and listen to you.
Okay.
I wouldn't be able.
That's fine, but can they at least tell me when my unit is going to be repainted? I've been there for 12 years. They told me once my stay.
Listen. I get you. And I wish we were in a day and age where, and I don't mean this in any disrespect to landlords, but where they would look at the tenants that have been there with them for a while and kind of take care of them. I get you. I
understand.
I fully appreciate that. We're not in that day and age.
Right.
So you need your unit. You think the unit should be painted.
Mm-hmm.
All right. Let me ask you this. Have you gotten the toilet fixed or no?
Excuse me?
Did the flushing of the toilet, has that been fixed yet or no? Okay. All right. So what else?
That's it.
Those are the two things.
Mm-hmm.
All right. Ms. Kazari, you got somebody from your... When was the last time your unit was painted?
When I moved, when Hamilton Crossing, I moved there in June of 20. When did I move there? In 2012, June 27, 2012, when I first moved into.
So it's been over 10 years.
Yes.
Okay. All right.
And I haven't heard nothing about my unit being painted. Oh, let me shut up.
No, you just want to yell at me.
No, I don't. I told you I watch you all the time. You too. Even when I'm at work, I watch you. I go in the bathroom and watch you. I'm saying, looking at my job. No, I'm saying I do.
Well, thank you.
This is where the emotional weight of the case truly comes into focus. The tenant isn't withholding rent out of defiance or neglect. She genuinely loves her home and has called it hers for over 12 years. That kind of loyalty says a lot, but it also raises a difficult question. How long should anyone have to wait for essential maintenance before?
And I think you're a fair judge.
Well, thank you.
Bottom line. I've always said that about you.
So, can we get her unit painted?
So my client's making a call to see about what the situation was with that. My maintenance is here. They've indicated that the toilet has been repaired from whatever last work order.
No, that's not true.
It's been out there twice.
It's been out there twice.
Is that correct? Yeah.
Let me don't.
Okay. That's not true. That's not true. That's not true.
Okay. All right. So here's what we're gonna do. Can somebody go out and just check it and just see if make sure it works or something is blocking the float and just stop? Okay. That's a simple fix.
But what I'm saying to you is that's not true. He's saying that he's been to my house 2 times. He couldn't have been there on October 23rd.
Miss Chambers.
He ain't been there.
Listen. Okay, just listen to me. And if you say you watch me, then you know.
Yep.
Come up here and tell me different things all the time, right?
Mm-hmm.
And I have to try to figure it out.
Yep.
Sometimes what somebody's saying on one side and what somebody, it doesn't matter to me.
Okay.
I'm just looking at the issue.
Okay.
So whether I find that what he's saying isn't true or true, you still have the problem that the float or the toilet, something's happening, right? So let's get to that issue.
Okay.
Does that make sense?
Yes.
Okay.
The maintenance supervisor can go today if that works for you.
So he has to wait till I get home because I have my people in there in my
What
line.
time?
So I don't know. I have some doctor's appointments today.
Are you going to be out in the street? No, I'm just kidding. you need to give him a time, Miss James.
3. Whichever you. Okay.
Okay. All right. So 3:00 today, they're going to come look at that. We're
Okay.
waiting on the toilet. So here's how much is owing at this point?
Your Honor, right now, $4,590. I understand Ms. Chambers does have some money in escrow.
Yes. And I have, can you total that for me? Excuse me? Excuse me? You knew I was going to ask? So how much is in there? So as I subtract that off of what they're saying, it's 4590 is owing?
Yeah.
So what's that, Marty? What's the difference?
372.
Thank you. All right. So if I release the escrow, when can you pay the 372?
I don't know.
Before they decide they've reached their limit. And beyond that, shouldn't long-term tenants who pay on time and care for their space receive a higher standard of respect and attention from their landlords? And then comes a moment straight out of internet legend, the kind of clip that could go viral in seconds. With a mix of honesty and humor, the tenant admits she once watched the judge at work while in the bathroom. Call it commitment, call it curiosity. Either way, it breaks the tension in a hearing that
I live on Social Security.
No, I got you. So I'm just trying to figure out when you can do that.
Okay, so why is 373 owing? Was that include late charges? Because my rent has not.
I don't know because I'm just
What does
going
that
off of
include?
what their figure
Might tell me.
is, and then
Because my money's been in escrow before the 5th of every month.
Okay, all right.
I have a copy of your ledger I can give to you. There is.
So I think how much is your monthly rent?
703.
Okay, so November, December, and January should not have late fees.
Should none of them have late fees?
Just
Okay.
Will you please?
Okay.
I say something.
I'm just gonna
gotta-
zip it. I ain't saying nothing else. So I leave out this.
No, you keep telling me that.
I ain't
Then
gonna say that.
every time. There you go again.
Okay, thank you.
So, Scazzeri, for specifically November, December, and January, are there late fees on the account?
There is a $50 late fee for November and December. And since she paid money into escrow, we'll waive them.
Right. So that would bring it to 272 as the balance, which is basically the court cost.
I'm just waiting to see if I can talk. What I'm saying
Well,
is,
we've learned something, haven't we?
my money has been in escrow since August. I have never been late in putting my money in escrow. So how are they saying that I owe late charge for from August, September, and October?
Your Honor, there's also a late fee for September as well as October in my client.
Okay.
She'll waive those. So that's another. So 172.
Why should
Is that just?
Okay.
Man, is that a better number?
No. Because I have not been late putting my money in escrow since August. I have my
Okay, so Miss
I think that's, so there is no late fee for August.
There's no late fee for August. Okay. So, and they're waiving any late fee for September, October, November, December. That's a 200. And so what it is you're about 172 short, which is really going to basically be the court cost. That's
otherwise been heavy with frustration and legal back and forth. It's a quick reminder that behind every case are real people, complete with quirks, struggles, and even the occasional comic relief. Now, let's break down the numbers. Because in cases like this, the math tells its own story. The original balance sat at more than $14,500, a figure heavy enough to keep anyone up at night.
Okay.
Does that make sense to you?
Yeah.
Are you mad?
No.
I don't know. Does she look mad, Alan?
Come on, Stefan. Now you.
Yes, ma'am. So that's another 50?
Well, no, it's not on the ledger.
It's not on the ledger. So you didn't give the 50 in the number you gave me?
No.
Okay. So thank you, though. See, everybody's trying to do something.
I know.
All right.
And I appreciate it.
No, you don't.
Yes, I do.
All right. So 172, when do you think you can get that paid? Okay, let me tell you why I'm asking that that way. I would release all of this escrow to the plaintiffs.
Okay.
They get that.
Okay.
What I'd like to do is because I believe you, I think we're going to figure out the painting. They're going to come do the toilet.
Mhm.
And then I'm just looking, I could issue a judgment. I really don't want to because the money's there. But we just are 172 short.
Okay.
So what I'd like to do is get to a point that's paid. I can get
I'll put it
arrangements
with
on the
my
other thing.
February rent. I mean, it'll put me in a bind, but I'll do it just to get it off me.
See, I wish I didn't like you. This would be a lot easier. So, all right, here's what I'm going to do. You have your Social Security check come each month. Is that?
Yes, I get my Social Security
Is it
check
the
on
first
third.
of the month, basically?
The third.
Third. Okay. Divided by 2. No, divided by 3. Thank you. All right. So here's what I'm going to do. Realizing she's on the fixed income, I'm going to release all of this escrow.
But after escrow arrangements and careful documented tracking, that towering amount has been whittled down to just $372. This isn't only about legal maneuvering. It's about financial survival playing out right in front of us and through it all. The judge is navigating a delicate balance, weighing fairness for the tenant against the responsibility to uphold the rules. Late fees are off the table, and a judgment has been sidestepped entirely.
Let's do this in form of a conditional dismissal. Have we determined that the unit can be painted? Is that?
Painted. We are actually seeking bids from contractors.
Gotcha. So that process, how long will that take? I mean, for you to?
It has maybe a week or 10 days or something like that.
So by February, could our unit be painted?
I don't see why not.
Okay.
I think we'll definitely have the bids by then. Also,
You'll have the bids by then? All right. So let's do it this way.
sorry to interrupt, but we also need dates and times that the contractors can go into the.
Right. I just need them to notify.
Got it. Okay. So let's do this. Why don't we put in the conditional dismissal that our unit will be painted by, we'll just do my birthday, March 31st. Thank you. I'm just trying to get there. All right. So her unit will be painted by then. That somebody will come out today to look at the issue with the toilet. And then that she will pay. So that's not going to give us 3. Well, we'll do it 3. That with her February rent, March rent, and April rent, she'll pay an additional, along with her rent, $57.33.
Okay.
And then that will pay that amount off, not cause a big burden on you.
Okay, thank you.
Okay. And we could do it in the form of conditional dismissal, get that done, no judgments entered. That's
Okay.
it.
That's fine.
Okay.
Okay.
How's that sound?
That sounds pretty good to me.
I didn't think I'd make it through a hearing with her. I did not think I'd make it through a hearing.
Regarding conditional dismissal, so timely rent as well.
Yes, timely rent with the additional.
So it's paid on the
50s.
first of the month, or
She gets her check on the 3rd,
okay, so it's paid
So-
on the third by the third.
but
I usually pay it by before the 5th because that's when late charges.
the late charges hit on the
5th.
5th. So pardon? They hit on the 6th, right? She has the 5 days. So by the 5th of the month.
Yeah, I'll have it in there.
I know you will.
And so if there is a missed payment, an affidavit of noncompliance is submitted to the court with an order of eviction and a judgment.
Yes.
Right?
No additional hearing. Correct.
Objection notice is waived. 56-day rule is waived.
Right. And but she'd get copies of, there'd be some notice to her.
Yes.
Okay.
Yeah.
Okay. So you understand that, ma'am?
Yes.
Okay. So they get a judgment, they get an order of eviction
Mhm.
if you don't comply with those terms.
I'm going to apply.
I know you. Always gotta say something. I know you will. And all I'm then saying is, if something happens, payment comes in for whatever reason, just whatever, life, something happens in between and it doesn't get credited to your account, whatever, you'll have notice of that so you can get to the office and
Okay.
work out okay. I just want to make sure that you know that.
All righty then.
Okay. So what I will do, you also had 3 business days to think about this. If there's some legal reason, some misunderstanding, some confusion as to any right or a right you didn't assert, you'd have to file a motion with the court within those 3 business days to set aside the conditional order of dismissal. You understand that?
Mhm.
Any other questions you have
No, but
regarding
I'm
that?
not going to do that.
Fantastic. All right. Thank you so very much. I'll
Thank you
mark
so
it
much very much. You have a blessed
guilty and
day.
get that into it.
entirely. What we're witnessing is a court making a clear effort to provide relief without opening the door to a precedent that could ripple through future cases. It's a delicate balancing act, enforcing the law while still recognizing the humanity of the people standing before the bench. In this moment, the judge seems to be leaning toward compassion, showing that justice can be firm without being cold.
Pick up the check today, or do we need to?
If I order it, okay. Yes.
Okay, perfect.